Types of void agreements. Under the Indian Contract Act, 1872, certain agreements are expressly declared void. These agreements are not enforceable by law because they are against law, public policy, or essential requirements of a valid contract. The main types of void agreements are explained below. Agreement without consideration, Section 25. An agreement made without consideration is void, except in certain cases like agreements made out of natural love and affection, past voluntary services, or a promise to pay a time-barred debt. Consideration means something in return. As a general rule, an agreement without consideration is void. This rule is given under Section 25 of the Indian Contract Act, 1872, which clearly states, an agreement made without consideration is void. This is based on the principle no consideration, no contract. If one party promises something without getting anything in return, the law normally does not enforce such a promise. However, Section 25 provides certain important exceptions where an agreement without consideration is valid and enforceable. First, an agreement made out of natural love and affection is valid even without consideration, provided it is in writing, registered, and made between parties standing in near relation, such as parents and children, husband and wife. For example, a father promising in writing to give property to his son out of love is a valid agreement. Second, a promise to compensate for past voluntary services is valid. If a person has already done something voluntarily for another person, and later the other person promises to compensate him, such a promise is enforceable even without consideration. Third, a promise to pay a time-barred debt is valid if it is in writing and signed by the debtor. Even though the debt cannot be recovered by law due to limitation, a written promise to pay it makes the agreement valid. Apart from these exceptions, agreements without consideration are void and create no legal obligation. The law does not support mere promises unless they fall within the exceptions provided under Section 25. Thus, consideration is an essential element of a valid contract. As a rule, agreements without consideration are void, but Section 25 clearly recognizes certain exceptions where such agreements are legally enforceable. This provision balances strict legal rules with fairness and moral obligations. Agreement in restraint of marriage, Section 26. Any agreement which restricts a person's freedom to marry is void. Marriage is a fundamental right, and law does not allow unreasonable restrictions on it. An agreement in restraint of marriage is an agreement which restricts or prevents a person from marrying. According to Section 26 of the Indian Contract Act, 1872, every agreement in restraint of the marriage of any person, other than a minor, is void. The law considers marriage a matter of personal liberty and social importance, so no one should be forced or restricted from marrying by a private agreement. Such agreements are void in nature, whether the restraint is total or partial. Even if the agreement allows marriage only under certain conditions, such as marrying a particular person or not marrying for a certain period, it is still considered a restraint and is therefore void. The purpose of Section 26 is to protect individual freedom and public policy. Marriage is regarded as a social institution, and any agreement that interferes with a person's right to marry is against public interest and morality. However, this section does not apply to minors. Agreements restraining the marriage of minors are not covered under Section 26 because the law already regulates the marriage of minors under separate personal and statutory laws. For example, if a person agrees not to marry anyone in order to receive property or money, such an agreement is void. Similarly, an agreement that imposes a condition that a person must not marry without consent of another is also void. Thus, under Section 26 of the Indian Contract Act, agreements that restrain marriage are void because they violate personal liberty and public policy. This provision ensures freedom of marriage and prevents unjust restrictions imposed through private agreements, making it an important topic for LLB examinations. Agreement in restraint of trade, Section 27. Agreements that restrict a person from carrying on a lawful profession, trade, or business are void, except reasonable restrictions allowed by law. An agreement in restraint of trade is an agreement which restricts a person from carrying on a lawful trade, business, or profession. According to Section 27 of the Indian Contract Act, 1872, every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is void. The law supports freedom of trade, and no one should be stopped from earning a living through lawful means. The restraint may be total or partial, but in India, both are void. Even if the restriction is reasonable in time or place, it is still void under Section 27. This is different from English law, where reasonable restraints are sometimes allowed. The object of Section 27 is to protect economic freedom and public interest. Any agreement that limits competition, prevents a person from working, or stops someone from starting a business is considered against public policy. However, there are certain exceptions to this rule. An important exception is related to the sale of goodwill. When a person sells the goodwill of a business, he may agree not to carry on a similar business within reasonable limits of time and place. Such an agreement is valid because it protects the buyer's interest. For example, if an employee agrees that he will never work anywhere else after leaving a job, such an agreement is void. But if a shop owner sells his business and agrees not to open a similar shop in the same area for a reasonable time, it is valid. Conclusion. In conclusion, agreements in restraint of trade are generally void under Section 27 as they restrict freedom of trade and profession. Only limited exceptions, like the sale of goodwill, are allowed. This section plays an important role in protecting individual liberty and maintaining healthy competition. Agreement in restraint of legal proceedings, Section 28. An agreement which prevents a person from approaching the court or limits the time for legal action is void. An agreement in restraint of legal proceedings is an agreement which restricts or takes away the right of a person to approach a court of law. According to Section 28 of the Indian Contract Act, 1872, any agreement that prevents a person from enforcing his legal rights through usual legal proceedings is void. The law gives every person the right to seek justice from courts, and this right cannot be taken away by private agreements. Such agreements are considered against public policy because they interfere with the proper administration of justice. If parties are not allowed to go to court, it may lead to injustice and misuse of power by stronger parties. However, Section 28 allows certain exceptions. Agreements that refer disputes to arbitration are valid because arbitration is a recognized legal method of dispute resolution. Similarly, agreements that limit the time within which legal action can be taken, as permitted by law, may also be valid. For example, an agreement stating that a party shall never file a suit in court to enforce his rights is void. But an agreement providing that disputes will be settled through arbitration instead of court proceedings is valid. Thus, under Section 28 of the Indian Contract Act, agreements that restrain legal proceedings are void as they deny access to justice. At the same time, lawful exceptions like arbitration are allowed. This provision protects legal rights and ensures fairness. Agreement with uncertain meaning, Section 29. An agreement is void if its terms are vague or uncertain, and the meaning cannot be made certain. An agreement with uncertain meaning is an agreement in which the terms are not clear, definite, or capable of being made certain. According to Section 29 of the Indian Contract Act, 1872, agreements, the meaning of which is not certain or capable of being made certain, are void. The law requires clarity in agreements so that the rights and duties of parties can be clearly understood and enforced. If the terms of an agreement are vague or ambiguous, the court cannot determine what the parties actually intended. In such cases, the agreement becomes void because it is impossible to enforce something that is unclear. However, if the uncertain terms can be made certain, the agreement is valid. For example, if the price or subject matter can be determined later by a fixed method or reference, the agreement will not be void. For example, an agreement stating that A will sell 100 tons of oil without specifying the type of oil is void due to uncertainty. But an agreement stating that A will sell oil at a price to be fixed by the market rate on a particular day is valid because the price can be made certain. Thus, Section 29 ensures that only clear and definite agreements are enforceable by law. Agreements with uncertain meaning are void because they create confusion and disputes. This provision highlights the importance of clarity in contracts. Wagering agreements, Section 30. Agreements based on betting or gambling, where gain or loss depends on an uncertain event, are void. A wagering agreement is an agreement in which two parties agree to win or lose money or something valuable depending on the outcome of an uncertain future event. According to Section 30 of the Indian Contract Act, 1872, agreements by way of wager are void. This means such agreements are not enforceable by law, and no party can claim the winnings in a court of law. The main feature of a wagering agreement is mutual chance of gain or loss. Each party has an equal chance to win or lose, and neither party has control over the event. Also, in a wager, the parties have no interest in the event itself, except for winning or losing money. Wagering agreements are considered against public policy because they promote gambling and speculation, which may harm society. Therefore, the law does not support or enforce such agreements. For example, if A and B agree that A will pay B 1,000 Indian rupees if India wins a match and B will pay A 1,000 Indian rupees if India loses, this is a wagering agreement and is void. However, it is important to note that not all contingent agreements are wagering agreements. Genuine insurance contracts are valid because the insured party has an insurable interest in the subject matter. Thus, wagering agreements are void under Section 30 because they are based purely on chance and encourage gambling. This provision helps maintain social morality and legal discipline. Agreement to do an impossible act, Section 56. An agreement to do an act which is physically or legally impossible is void. An agreement to do an impossible act is an agreement where the act promised cannot be performed. According to Section 56 of the Indian Contract Act, 1872, an agreement to do an act which is impossible in itself is void. The law does not recognize or enforce agreements that are impossible to perform. If an act is physically or legally impossible at the time of making the agreement is void from the beginning. For example, an agreement to discover treasure by magic or to bring a dead person back to life is void because such acts are impossible. Section 56 also covers cases where a contract becomes impossible or unlawful after it is made due to some event beyond the control of the parties. This is known as the doctrine of frustration. In such cases, the contract becomes void at a later stage. For example, if A agrees to perform at a concert on a particular day, but before that day the concert hall is destroyed by fire, the contract becomes void due to impossibility of performance. Thus, under Section 56, agreements to do impossible acts are void because performance is not possible. This provision ensures fairness by relieving parties from obligations that cannot be fulfilled. Agreement with unlawful object or consideration, Section 23. If the object or consideration of an agreement is illegal, immoral, fraudulent, or against public policy, the agreement is void. An agreement with unlawful object or consideration is an agreement where the purpose, object, or the consideration is not permitted by law. According to Section 23 of the Indian Contract Act, 1872, an agreement is void if its object or consideration is forbidden by law, or if it defeats the provisions of any law. An object or consideration is also unlawful if it is fraudulent, immoral, or opposed to public policy. The law does not enforce agreements that harm society, morality, or the legal system. For example, an agreement to give money for committing a crime, such as theft or murder, is void. Similarly, an agreement to bribe a public servant or to carry out an immoral act is also void because the object is unlawful. If any part of the consideration or object is unlawful and cannot be separated from the lawful part, the entire agreement becomes void. This ensures that parties do not indirectly enforce illegal purposes through contracts. Thus, Section 23 clearly states that agreements with unlawful object or consideration are void. This provision protects public interest, morality, and the rule of law. Agreement with incompetent parties, Section 11. Agreements made by minors or persons of unsound mind are void as they lack capacity to contract. An agreement with incompetent parties is an agreement made by a person who is not legally capable of entering into a contract. According to Section 11 of the Indian Contract Act, 1872, every person is competent to contract who is of the age of majority, is of sound mind, and is not disqualified by law. If any of these conditions are not fulfilled, the agreement becomes void. A minor is not competent to contract, and any agreement made with a minor is void ab initio, meaning void from the beginning. The law protects minors from contractual liability because they are not considered mature enough to understand the consequences of contracts. Similarly, a person of unsound mind, such as someone who is mentally ill or intoxicated at the time of making the agreement, is not competent to contract. An agreement made during such a condition is void. Persons who are disqualified by law, such as alien enemies, insolvents, or convicts, in certain situations, are also incompetent to contract. Any agreement made with such persons is void. Thus, agreements with incompetent parties are void under Section 11 because legal capacity is an essential element of a valid contract. This provision ensures protection for vulnerable persons and promotes fairness in contractual dealings. Conclusion: void agreements under the Indian Contract Act, 1872. In conclusion, the Indian Contract Act clearly lays down that certain agreements are void because they lack essential elements of a valid contract or are against law, public policy, or morality. Agreements without consideration, in restraint of marriage, trade, or legal proceedings, agreements with uncertain meaning, wagering agreements, agreements to do impossible acts, agreements with unlawful object or consideration, and agreements with incompetent parties are all treated as void by law. These provisions ensure fairness, clarity, and protection of public interest. They prevent exploitation, discourage illegal and immoral activities, protect personal freedom, and promote legal discipline. Understanding void agreements is important to clearly distinguish between valid, void, voidable, and illegal agreements and to apply these principles effectively in examinations and practical legal situations.